Sorry, that was fun. Sorry, you can't see what I can see, but the production crew back there, and you can see them all just going like, turn on the microphone, buddy. Okay, there you go. So we're just going to clip through because we've got to give a lunch in there. Okay, now our next presentation was on cybersecurity, and I don't know if everybody, we tend to think about security, and then there's privacy, and privacy adds a whole new element to this in there, and it's something that I think a lot, the two of them go together in there. At a publication, I'm a member of the CIO Association of Canada, CIO-CAN, and we had one of our members published a paper called Death by Compliance. And we have these discussions. Like one CIO I talked to has one full-time person just filling in compliance documents on privacy and telling their suppliers why they're not going to lose their data and all that sort of stuff. So privacy is a key concern. Now, if you've been around long enough, you know that legislation is being written and changed in a number of jurisdictions. We had it in Ontario. There was PIPEDA, I think it's decades old, almost decades old now. It hasn't been updated. But now there's a big move to update this. So, but love it or hate it, it's here to stay. We're going to be seeing a lot more of it over the next little while in there. And so I thought it was essential for the MapleSec audience that we would give a good overview of our current and proposed legislation and regulation. So Wendy Hulton, and she's a partner at Dickinson Wright. And Wendy, are you here? Because so please come on up. So Wendy was agreed to take on this challenge. Now, I want you to root for her. She's going to do privacy legislation in 25 minutes. Wendy, welcome. I don't want to take any time from you, so I'm getting off the stage.
I'm going to talk very fast.
Great. Okay. We don't have to talk fast. Just we'll wait for you. If you talk fast.
Where's my little clicker?
Are you on the speaker one? That'll move your slides.
That will move my slides. Okay.
Yeah. You can see them
down there. Okay, awesome. So thank you everybody for joining us. This is my first in-person presentation since the pandemic, so bear with me. I'm not used to speaking in person. As Jim mentioned, I'm a regulatory lawyer at a cross-border law firm called Dickinson Wright. As a lawyer, that means that I work with organizations both before, during, and after cyber incidents. So as Jim mentioned, my topic was supposed to be keeping up to date, the essential guide to privacy and security. And then when Jim and I talked about it, what we very quickly realized is that in 15 to 20 minutes, I would be doing this audience a disservice. I cannot give you an update in 15 to 20 minutes. Things are moving way too quickly. There's too many moving parts. What I am going to do, and this is what Jim and I talked about, is try and give you a whirlwind update from the legal perspective. And I'm going to pick up on a lot of the themes that you've already heard today. And I'm going to give it to you from the legal perspective. And what I'm going to do is talk about what's keeping the chief technology officers up at night. And I'm going to do that from the cybersecurity privacy legal trenches. So from the legal perspective, you've heard a lot from the technical perspective. So let's start with Quebec. One fairly recent example from Quebec is Bill 64, which passed into law what's known as the Privacy Legislation Modernization Act, otherwise affectionately known as Law 25. Law 25 came into effect on September 22nd. Now, Quebec is late to the breach reporting game, but they came in a big way. They're not messing around. Businesses that fail to report a confidentiality incident could now face fines of up to $25 million or more. So what is exactly a confidentiality incident? Well, we know what PIPEDA says. PIPEDA defines a breach of security safeguards as the loss of or an unauthorized access to or unauthorized disclosure of personal information resulting from a breach of an organization's security safeguards or from a failure to establish those safeguards. Now, Law 25, on the other hand, defines a confidentiality agreement as one of four things. It could be access not authorized to personal information. It could be use not authorized by law to personal information. It could be communication not authorized by law of personal information. It could be loss of personal information or any other breach. So I think we can all agree that all those four things probably happened about 5 billion times in the last few minutes across the city. So the question is, and it's too soon to know whether this new definition is going to have a huge impact, but I think we can agree that it's much broader than the definition under PIPEDA. So what do organizations do that operate in Quebec? Well, they have a new reporting obligation. So if they believe that confidentiality incident has occurred, then they have to report to the Quebec organization, which I'm going to mangle the name, but it's the Commission to Access Delivery Information, or what we refer to as the CAI. The other thing that organizations have to do is some record keeping. Organizations are required to keep a register of all confidentiality incidents. So under PAPETA, it was 2 years. Under the Quebec legislation, it's 5 years. And failure to report an incident can result in fines of up to 25 million or more. And I wonder, this is what I wonder for this group, is whether the CEOs have been advised that by default, they actually are the person with the highest authority in the organization. And under Law 25, they are now the person who's responsible for the protection of all the personal information under Law 25. The good news is they can delegate it. So speaking of which, do your employment agreements cover going to jail? I'm sure everyone's heard about Uber Technologies' Chief of Security Officer, Joe Sullivan. Joe's a pretty popular guy in the news. He was recently convicted by a U.S. jury of hiding the 2016 data breach from the U.S. Federal Trade Commission. Apparently the San Francisco jury rejected his defense that the other executives knew about it. In fact, he actually had sent an email to the CEO about 12 hours after the hack was discovered, he alleges. But anyways, they've still convicted him of obstructing government investigations and concealing the theft of over 50 million customer information, including millions of Canadians' data. So the bottom line is the 2016 Uber hack stayed secret until November of 2017. The evidence at trial is kind of interesting. So Sullivan was hired as Uber's chief security officer in April of 2015. This was just right after they started investigating the 2014 hack. And Sullivan basically took over reporting and dealing with the hack and dealing with the FTC. He actually testified under oath at great length to the FTC on November 4th, 2016. Remember that date, November 4th, 2016, regarding Uber's security practices. And in his testimony, he specifically said he addressed the steps that he claimed Uber had taken to keep customer data safe. Exactly 10 days after he testified to the FTC, he learned that Uber had been hacked again. In fact, the hackers were really kind. They sent him a personal email to let him know about it. And then he sent off his employees to check, and lo and behold, it was true. They had been hacked. They'd lost tons and tons of data. So 10 days after testifying to the FTC, what does Sullivan decide to do? Well, he decides not to report this massive hack to the FTC, or to any other authorities for that matter. Reports actually indicate that Sullivan told his subordinates, "We can't let this get out." He instructed the information needed to be, quote, tightly controlled. And the story outside the security group was to be that this investigation does not exist. So what does he do? He decides to pay off the hackers in exchange for signing non-disclosure agreements, in which the hackers promised not to reveal the hack to anyone. And also, it contained the false representation, of course, that the hackers didn't take or store any of the data in their hack. So let's think about this for a minute. How effective do you think it is entering into a legal agreement with a criminal? Well, Uber paid the hackers $100,000 in Bitcoin in December 2016 without even getting the hackers' real names. But wait, in 2017, they actually identified the names of 2 of the hackers, and they asked them to sign updated NDAs with their real names. I wonder who prepared those NDAs, because it wasn't Uber's lawyers. Anyways, in the meantime, while all this is going on, Sullivan, meantime, is working with Uber's lawyers, wrapping up the handling of the matter with the FTC on the first 2014 matter. So in finding Sullivan guilty, the jury, it was pretty clear that, he knew about a felony. He took affirmative steps to hide that felony. He's currently waiting for sentencing. I haven't heard whether his sentencing date has been set, but he's facing a maximum of 5 years in prison on the obstruction charge, and another 3 years on the other charges. And yes, we have similar laws in Canada. And yes, this could happen here too. So, while we're on the subject of employees going to jail, I should mention 35-year-old Sébastien Vachon Desjardins of Gatineau, Quebec. He was recently sentenced to a 20-year prison term in what a U.S. federal court judge referred to as the worst case he's ever seen. In fact, the judge said if it had gone to trial, he would have given him life. Sebastian actually is a former IT specialist for Public Service and Procurement Canada. That's our federal government, right? And he decided to ditch his cushy federal job and his great pension and for a new career as a ransomware hacker. At his sentencing, it was clear that Sebastian had good parents, he was well educated, he had no mental health issues, he was not under any financial pressure. In fact, Sebastian's lawyer described him as polite, cooperative, and the best client he'd ever worked with. However, Sebastian pleaded guilty to 4 charges, including computer fraud and transmitting a demand in relation to a protected computer in the US. He actually was one of the more prolific affiliates of NetWalker, which is one of the ransomware gangs that was very, very active during the COVID pandemic. They were the ones that hacked into many health districts, schools, companies, etc. And if people didn't pay up, they posted it on the NetWalker blog on the dark web. In fact, NetWalker had 400 victims in more than 30 countries and collected $40 million in ransom payments that we know of. Sebastian, though, his little game was up in January 2021 after the RCMP searched his home and they found $28 million in Bitcoin and about $500,000 in cash. That's why when you don't leave $500,000 in cash lying around the house. Anyways, his big problem came in May of 2021 when he got extradited to the United States to face those charges that I earlier mentioned. Now, he's agreed to forfeit the money, but he is not going to provide information on his co-conspirators. So employees. So let's talk about employees more. So if you operate in Ontario and you have 25 or more employees as of October 11th, you will have shared with them your new employee monitoring policy. This isn't a big deal, folks, if you're in Ontario, because all you need is a document with a date on it and if and how your employees are being electronically monitored by the company. It doesn't prohibit you from monitoring employees. It doesn't provide them a mechanism for employees to complain about it, nor does it require any test as to whether the monitoring is reasonable or not. You have to contrast this with the legislation in both Alberta and BC where it has to be reasonable. Query what is reasonable. But anyways, the devil is always in the details. Here in Ontario, we don't have a definition. So things like passive monitoring, the stuff that you collect and you don't even look at, could be monitoring, and you need to disclose that. So with that being said, I think companies need to be careful about what they do tell employees that they're monitoring. You might want to strike a balance between that transparency and the need to actually protect what you're watching, right? So for instance, you might say, we're watching your email, but you might not tell them the granular level that we're screening for email addresses containing our competitor names, because then it would be very easy for the employee to circumvent your protection process. Basically, I usually recommend that you fall back on something really generic, like we're doing this because we need to do cybersecurity protection. We have to protect confidential information. Again, staying on the theme of employees, let's talk about our federal government. They're rushing, as we heard, to pass new laws, but they're not always leading by example. And let's look at a recent example. Health Canada was audited. And when you look at how Health Canada is handling their IT, you'll know that they're not doing a good job. In this particular case, the auditors couldn't confirm the existence or the location of 74% of the hardware assets, their IT hardware assets, 74%. Think about that, people. And 35,000 devices. So, that's our federal government hard at work protecting us. And they're the ones that want to make these laws. They couldn't find purchase orders for 51% of the assets. There was a lack of process on the management of the IT assets. They don't know where the USB sticks are, the laptops, the tablets, the computers. And there was a complete lack of adherence to the requirements for decommissioning their IT assets. So as we all know in this room, poor IT inventory management can lead to massive risks, right? You're going to have problems with your confidentiality if your assets are floating around. You're going to have breach of contractual obligations. As we've heard earlier, there's lots of contracts that have requirements to safeguard confidential information. And if you don't know where your stuff is, you're not protecting it very well. Do we have a picture of a judge? I'm talking about class action. So can we hold the government accountable for its sloppy cybersecurity? Well, the answer is maybe. The federal government, the federal court actually recently certified a privacy class action against Revenue Canada. This is the Sweet versus Canada case, and it arose from the cyber incident when Revenue Canada was accessed by hackers, and they used it to apply for the COVID-19 benefits. Because as we know, in the summer of 2020, A lot of the online accounts were subject of a credential stuffing attack by targeters who targeted specifically Revenue Canada and Employment Service Development Canada. So what happened is when Todd Sweet logged on to his account after getting an email saying his email address had been changed, he discovered that his direct deposit information had been changed, and lo and behold, he'd applied for several CERB benefits, which of course he hadn't. He's representing a class of thousands of Canadians whose online government accounts were vulnerable during that June to August of 2020 because the government didn't properly secure them. So generally speaking, when we're talking about class actions in cybersecurity, we don't get too fussed in Canada. And that's because aside from the legal expenses, they rarely generate large damage awards. And this is because the Canadian courts tend to closely scrutinize the evidence before certifying class actions. Right now, plaintiffs actually have to prove some nexus between the data loss and the actual damages that they've suffered. In fact, the Quebec Court of Appeal recently dismissed an action saying that they couldn't prove the causal link between the privacy breach and the subsequent incidents. So basically, it confirmed that, the anxiety and the inconvenience that we all suffer following a cyber attack is basically not compensable unless it's serious and prolonged. Now, that being said, a Quebec court also recently certified a plaintiff's out-of-pocket expenses for the cost of getting the credit reporting supervision. And another judge recently certified a class action by Quebecers against MGM Resorts in Vegas because the judge didn't want them to have to go the inconvenience of taking on a big US corporation in Nevada. Why not have the comfort of just suing them at home in Quebec? So that one's been certified. And then insurance. So we've heard about that earlier today, and I think there's some very good points that were made today about insurance. And I think some CIOs sleep better at night because they think they have good cyber insurance. And we don't have time today to obviously cover that in detail. And we heard today that the cyber insurance industry may be hitting a bit ahead. We heard a figure of 55%. That meant 55% of cyber claims were being turned down. That's what that gentleman was referring to this morning. So, I think the insurance company industry is running hard to keep up with the changes, but I don't see any of them going broke. They're still making money. So what I recommend you do is you cross-examine your insurance broker about exactly what your insurance coverage is. And that being said, insurance companies themselves are not immune to this type of litigation. In fact, there's a case right now in Illinois where two nominal plaintiffs have commenced an action against the famous insurer and broker Arthur J. Gallagher because they were a victim of a security breach and ransomware attack. The statement of claim actually alleges that between June 30th, 2020 and September 26th, 2020, the employees, the customers, and the clients were not notified almost until a year later. So the hackers had access to lots of great information because, insurance companies collect lots of information from us. They had, they had driver's license, they had passports, they had electronic signatures, they had medical data, they had everything. And the claim points out that Gallagher, who's actually in the business of obtaining and placing cybersecurity for its customers, should actually know the risks that is posed by theft of data. And for the fact that they sat on that information for a year while that data was out being sold on the dark web. Of course, it was going down and down in value over that year, but it was still being sold before people were even alerted to the fact that their data was out there being sold. So we've heard lots already today about what you should do when you're a victim of a ransomware attack. But one thing from a legal perspective, I would say, is be careful of your timing, right? You're letting various parties know at various times. And trust me, everybody's going to scrutinize when you go to the media versus when you tell the victims versus what you tell to the privacy commissioners when you're doing reports. So think about your timing. Okay, but how good a job did you do? If you want to learn from others' mistakes, I recommend that you read the Privacy Commissioner's report on the Marriott situation. Marriott fell pretty far short, according to our Federal Privacy Commissioner. There's 89 points to their report. I'm going to go quickly because I'm running out of time, but the bottom line is they made it very clear that Marriott did an inadequate job. They said Marriott could have done a lot of things, like they could have done more comprehensive logging and monitoring measures. They could have adequately applied their multi-factor authentication process. They could have adequately had accountability measures. They could have had sufficient measures in place when Starwood systems came online to encrypt confidential information. One of the things they found is that Marriott was sitting on data from 2002. There was absolutely zero reason for them to be sitting on customer data from 2002, but they didn't know about this until they learned the hard way going through this whole process. So the issues that were examined in the Privacy Commission's report, and like I said, I commend it to you, is they need to look at safeguards. So was the information being held by Marriott properly protected? We've heard lots about that today. Was there accountability? In other words, did Marriott demonstrate due diligence to take steps to fulfill its responsibility? Did they retain their information too long? And did they notify their individuals and mitigate their measures properly? Personally, I say no, because I found out first in the media. I didn't find out first from Marriott. So we know from this report that Marriott's logs didn't monitor or audit privileged or administrator accounts. We know that Marriott was not archiving its firewall logs for at least 12 months, which is kind of minimum. They didn't engage in timely information deletion process. We have all kinds of things. But again, at the risk of sounding like a legal commercial, the part of this is that's really take-home message from the lawyers is due diligence. You have to do your homework. And I think we've heard lots about that today. And I'm pretty much out of time, but I just want to talk about one thing on the proposed national pause on the use of facial recognition technology that's been proposed by our Federal Standing Committee. And of course, that means we won't be able to unlock our iPhones much more. But the bottom line is, I don't like when our federal government rushes legislation, right? Right now, Quebec is the only jurisdiction that has laws that deal with biometrics. And in that case, it requires organizations to notify, again, that authority I spoke about earlier, when you're implementing a biometric process. And facial recognition isn't new, right? The Insurance Bureau of British Columbia has been using it for 20 years. And of course, we know about the class action that PIPEDA, under our existing PIPEDA, that under Canadians filed against Clearview, right? So last but not least, I think that cybersecurity starts at home. Employees at small and medium-sized firms have been given a C rating for their knowledge of cybersecurity. And I'm not going to repeat because everybody's been talking about that today. But what we know is that from the OPC, 93% of the breach reports received by their office in 2021 involved human error. And only a third of the respondents said their company provided the mandatory training. Only half said their organization had introduced multi-factor authentication, and only a quarter said their employee conducted phishing simulations. So I'm pretty much out of time, but I want to thank you for joining me on what I think is a whirlwind tour of what I think should be keeping the CIOs up at night.
Huge challenge, and you took it very, very well. So you're going to be around to answer some questions, I hope? A little free legal advice, just okay. Aw, don't go. So, but we can get you back for a podcast, I bet you. We'll make sure we get the information out and you come back for one of our podcasts. All right. Thank you, Wendy. What a challenge. Thank you. Isn't that great? Having to take privacy legislation in 25 minutes. And I just, what I'm going to take away from this is, will I look good in orange? Yeah.